and welcome. Good to see everybody again virtually here, and look forward to it.
Okay, well, let's get going. Roles and responsibilities. The contract documents will establish the roles and responsibilities for construction administration and the roles amongst the parties. Each party needs to know their part and understand the expectations of each of the other parts. This is a little cartoon that I stole from Jim from a presentation that he's done in the past. It kind of shows the image of the three parties. You've got the architect kind of guarding the lions and the Romans, with the contractors being the lions and the Romans being the owner. And so contractually, you've got the relationship between the owner and the contractor, and then the architect kind of sits outside of that contractual agreement to kind of help keep the peace. I don't know why this thing keeps coming up. So let me try to see if we cannot get interrupted again.
Well, I'll just throw in there, Doug, I think one of the things that we have as a responsibility as architects is that word expectations. We talk about that often in being in the business of expectation management. This is an adversarial cartoon, and it's sort of sad that we find ourselves in that position all too often. It's meant to be humorous, but sadly it probably falls in this direction too often. So understanding exactly where we fit and what those responsibilities are certainly a great step in communication to keeping us headed in the right direction.
So let's start with the owner and talk about the owner's rights and responsibilities. The owner is required by the contract documents, and this is typically in the general conditions, and it's also found in the actual contract language between the parties. Let me try a different one. Okay. To provide information to the contractor. There are certain types of information that the owner needs to provide to the contractor so that the contractor can do what they need to do. Examples would be the legal description of property, subsurface review, technical investigation reports, any easements or issues like that that have to do with the land. That information runs with the land, and it is the owner's obligation to provide that information to the contractor. The owner is responsible for paying for certain fees and charges associated with the work. Approvals, easements, and other charges like that are typically what we're talking about there. A big one is make payment to the contractor, and I would say make payments in a timely manner to the contractor. Nothing can bog down a job more than having an unhappy contractor because he doesn't have his cash flow the way it should be. So making payments to the contractor is a big one. The owner has the right to stop work for good cause should a cause arise, and also should something happen, the owner can carry out the work if necessary on behalf of the contractor. The owner can perform work with his own forces. The owner can award separate contracts, and in such case, typically it is then the owner's responsibility to coordinate that work. A lot of times you will see if they do award separate contracts, they will delegate that coordination responsibility to either the architect or to a what we call it here a project expediter or the general contractor, somebody that's on site to kind of coordinates all of the separate contracts. But that responsibility would be the owner's, but then the owner can delegate that to another party. The owner has the right to clean the project should the contractor not be maintaining it in a clean manner. I have seen that happen on projects before where especially when it was like a highly visible site where the contractor was not maintaining the site in a cleanly manner, and is primarily due to his efforts in trying to get the work done to where the owner came in with his own forces and cleaned the site up, and then back charged the contractor for that cleaning efforts that he took part in. The owner typically in AIA contracts has the right to take partial occupancy of a project. You see this when projects are done in phases. You see it on the larger projects. Owner may need to get into an area to start setting up early before the work is complete. The contracts allow for them to take that partial occupancy early. And a big one for contractors and owners to be aware of is the owner's right to terminate the contract with or without cause. That is typically standard language in all construction contracts. Obviously, if the contractor's at fault, the owner has the right to terminate the contract, but the owner also has the right to terminate the contract without cause. So if there's no fault on part of the contractor, the owner can still terminate the contract. The contractor would at that point be entitled to payment for the work that he has done up to the termination point.
And I think, Doug, one of the things that is a possibility here when we're having a pre-construction conference and the work is getting ready to start, it's a great opportunity to go over these items, particularly with the representatives in the room, because I think depending on how sophisticated your owner is, often they are not sure about all of their rights and responsibilities, even though they're contracted and even though they're clearly spelled out in the documents. It's a good opportunity to stop and just point this out at the beginning as we're establishing those pathways of communication, and let everyone know what the other's responsibilities are in a fashion.
Jim, I think that's an excellent point, especially like you said, if you've got an owner that is not as sophisticated, has not done a lot of construction. They may have just gone out and hired an attorney and not even necessarily read the contract and are just trusting the attorney, and they may not know all of what it is that they're obligated to do. I think that's an excellent point. Matthew, do we have anything from the audience before we move on?
We don't have anything yet, so feel free to move on.
So next, we'll talk about what the expectations are of the owner. One, starting at the top, is to provide a reasonable contingency. And as design professionals who are involved in the process, especially if it's a traditional design bid build, we're involved in the process prior to the contractor coming on. I think it is incumbent upon us to inform the owner about what the contingency is, what it's used for, and what would be a reasonable amount to have for a contingency. And believe it or not, I've been on jobs where the owner has not even accounted for any contingency, which is not a fun place to be. I'm sure we've all been on jobs where the contingency that was established was not reasonable, or where the expectation was is that it's the owner's money, and it is the owner's money, but it's that for him to do whatever he wants to with it when he wants to change scope, and it's not for hidden conditions or errors and omissions. So, as Jim mentioned earlier, that communication, defining expectations is extremely important throughout the whole construction administration process, and I'm sure that theme will continue to show itself. Another expectation is full disclosure of all information required by the contract documents. Again, being open, upfront, honest, not trying to hide anything, sweep anything under the covers. The expectation is that the parties are going to be open and honest with each other. To be accessible for decisions and consultations. Throughout the construction process, there'll be As we all know, unforeseen conditions, change conditions, things will come up. The owner needs to be accessible so that they can be reached and that the right person can be reached to provide the input to make the decisions and to consult when those issues arise and that needs to take place. Expectation, again, prompt payment is a big one. Also, any modification of other documents that require owner approval, the owner needs to act on those promptly. Change orders, change directives, field orders, any kind of a modification to the documents. As you all know, the contract is between, as we said, the owner and the contractor. The architect is not, in most cases, a party to that contract. Their exception to that would be integrated project delivery if you signed a tri-party contract. But that agreement, again, between the owner and the contractor can only be changed by the owner and the contractor. The design professional cannot make those changes, so the owner needs to be accessible and needs to be on board to make those modifications and take care of whatever other documentations that they need to deal with requiring their approval. A big expectation for the owner on both the part of the design professional and the contractor is for the owner to be reasonable. We don't want owners out there making demands that are beyond the intent of the contract documents. That's never a good thing. Be fair in interpreting the scope of the work and to understand that changes may involve both time and money. So the owner needs to be reasonable if they are asking for a change, if there's an unforeseen condition, something that the parties did not anticipate. Be reasonable, be fair, come to a resolution that's amenable to all parties. The owner is expected to have the financial resources necessary to complete the project. Whether it is their own funding, whether it is having secured financing from some other source, be it a bank or somewhere else. Again, making sure that the contingency is there and that they are able to financially support the project. And then they are...
And Doug, I was just going to say there, you know, for example, in our state construction office, there is a requirement for the owner to substantiate that they do have those resources. And it's not a bad idea for a piece of your documentation to carry that requirement over, so that at the beginning of the project up front, everyone is assured that those resources are there. There may be an independent party that confirms that, so that you don't have surprises later in the job. And I think that would be appreciated certainly by the construction community.
In the AIA general condition documents, there is language in there where the contractor can ask to see that the owner is financially sound, and the owner, per the general conditions, is required to provide that information as well. So that is especially again if you're dealing with a client that has not done a lot of buildings. It's not like a college or university campus where they pretty much know that they have the funding. That could be something that's real important for the contractor before they even sign the contract, to make sure that the owner's financially sound. And then, as we said before, one of the owner's rights is to take partial occupancy. An expectation is that if they do so, that they understand what their responsibilities are for access, insurance, maintenance, allowing the contractor access. So all that is also an expectation for the owner. Matthew, anything from the audience?
No, it doesn't sound okay. It says, I just had a point here from Drusilla saying that sound is non-existent using VoIP. So I'm not sure if maybe there's some issues with the audio. I guess maybe if Jim and Douglas, if you might be able to speak up just a little bit, we'll see if that'll hopefully help.
Okay. Hopefully you can hear us. So we'll move on from the owner to the architect. And a lot of times the architect or design professional is kind of seen as a little kid in a place that just moving stuff around and kind of willy-nilly. So let's go ahead and talk about the architect's rights and responsibilities. The architect is contracted with the owner and is a representative of the owner to the extent defined by the documents. The architect is responsible for observing the work, and you need to make sure that you are reading over your contract. A lot of times, if it's not an AIA contract, the responsibilities for observing the work are expanded beyond what they say in an AIA contract, where you're doing work for or doing observations to extend it to where you're more in the role of supervising the work. So you just need to be careful about that. The architect is responsible for certifying and making recommendations, be it on a payment application where you are making a certification, issuing a certificate of substantial completion, reviewing a change order request, and making a recommendation to the owner on the validity of the change order request. The architect or engineer, design professional is responsible for interpreting the contract documents. And again, you need to be careful here in that you are interpreting the documents based on the design intent that's in the documents. You can't really expand beyond that because you figured out, oh, I missed something.
And one of the things that's important, and Doug talks about this all the time, that our actions are supposed to be from an impartial position. While we represent the owner, our decisions are supposed to be made based on fairness and a basis of impartiality, so that we are rendering information that isn't just to our benefit and often isn't just to the owner's benefit either.
That is very true, and I know in North Carolina that is even covered by our Practice Act. There is language in our, and I don't have it in front of me, there's language in our Practice Act and the statutes that govern the practice of architecture that talk about being fair and impartial while performing construction administration duties. And also, as the next item here is resolving disputes. You need to be fair and impartial, and you're kind of that first step, third party mediator between the owner and the contractor. And in disputes, typically, unless the newer AIA contract documents give the option of whether or not the architect's going to be that initial decision maker or not. But if you are, then you are to act in a fair and impartial manner in looking at the disputes, because the disputes go to the design professional first. The architect or design professional is responsible for modifying the contract documents should that become necessary. And there are many reasons why that may be necessary, be it an unforeseen condition, be it an error or omission, be it a contractor request, be it a owner request. The design professional is responsible for modifying those contract documents. Responsible for reviewing submittals, and again, this is another one where you need to be careful and review the language that's in your contract to make sure that you are doing those reviews in accordance with the terms of your contract. Because again, a lot of times the language might be expanded beyond what's in the typical AIA language to where you're reviewing for the design intent that's in the documents. It might be expanding it to where you are actually responsible for verifying dimensions and safety issues and a whole host of stuff. So just make sure that you read your contracts, and if you see that language in there that's expanding it beyond what you typically would do, that either you negotiate it to get it to where it needs to be, or you negotiate to get compensated for what it is, for the additional services that you are being asked to perform. The architect's responsible for performing inspections. And again, it does say inspections, and I know that's kind of been a no word for the architectural profession after some cases a while back, but the documents still do provide that we perform inspections, and that is typically at substantial completion. The site visits are not inspections. Those are visits to observe the status and quality of the work, but at substantial completion we are actually doing an inspection to determine substantial completion. So the expectations of the design professional from the owner and the contractor: that the documents that the design professional has prepared comply with the standard of care. Now, again, that standard of care language, you need to check your contracts. Typically, if it's not stated in the contract, what the courts will state is that the standard of care is what a similarly situated architect would do in a similar location on a similar project. It's average. If your contract says that the standard of care is going to be the highest level, if there's language in there about the best design, that type of stuff, that's raising your standard of care, and you need to be careful of that type of language. So again, the expectations, managing those expectations is critical, because if the owner is expecting, and I've seen this language in some contracts before, that the documents are going to be error-free, and you've signed up for that, I hope that you have taken that into consideration and gotten the fee and the time to produce a perfect set of documents. And I've never seen a perfect set of documents. So managing those expectations and what that standard of care is extremely important. The design professional is expected to inform the owner of the progress and the quality of the work, and that's the purpose of those site visits. Next month we're going to talk about field reports, which are the documents that we generate after we make a site visit, and typically what we use to inform the owner of what the progress and quality of the work is. So I wanted to, since we're here talking about this now, I want to just ask folks, in case we run out of time and don't get to it at the end, if you don't mind, if you would please send to either Jim, myself, or Matthew some examples of your field reports that you've done. We want to kind of talk about what goes into a field report and how you put it together, and want to have some multiple examples, so if anyone is willing to, and if you want to black out project names or firm names or any kind of identifying information, that please feel free to do so, but we would really like to get some examples of some field reports from you folks to talk about next month. The design professional is expected to be knowledgeable and professional, to be accessible and prudent with the owner's budget. You're designed to a budget. You want to make sure that you are keeping that in mind, and that you're not over-designing, and you're not trying to grab contingency money to deal with an over-designed project because you have not paid attention to the owner's budget. The design professional is responsible, or is expected to evaluate any proposed change orders, be they owner requested changes or unforeseen conditions or contractor requested changes. And we mentioned this before, the expectation is to be fair and reasonable in interpreting the contract documents, and I would also say in resolving disputes. The expectation is for the design professional to process documents timely. Payment applications, RFIs, submittals, all that paperwork that comes through during the construction phase needs to be processed in a timely manner. You don't want to sit on a submittal for 2 weeks and then return it when you haven't looked at it and say, oh, there's something wrong with it. You need to resubmit this, and you haven't taken the time to look at it to see whether or not it's the proper manufacturer or something like that. Time is of the essence in every project I've ever been on, and processing again pay app so that the contractor's cash flow is there, and so he's happy. Responding to questions so that you're not slowing down the progress of the work. Extremely important. Jim oftentimes talks about submittals. You may have contracted in your agreement that you will take 21 days to review submittals. And again, you don't want to sit on it for 2 weeks and then send it back. So you want to, make sure you jump on that stuff quickly.
Well, that's right, Doug, and I think, like you said, we establish and write. We're the author of those general conditions, and we've all worked in our firms, and we know what we're good at. We know what we're not so good at, and we have the opportunity to create a period of time that is reasonable within those general conditions. And one of the things that I've seen be really successful is to have that expectation management meeting, that pre-construction conference, where you sit down and spend time mapping out, exactly what submittals are going to come in. It's clear what some of those are that are needed quickly and up front. It's clear that some of them are not necessary right away. If you can put that into your specifications, that's great. If you could work out a submittal schedule of expectations and when things would come in, that's great. Some of you have shared stories, even on these phone calls, where the contractor came to the pre-construction conference with, 30 submittals in a stack. Probably they weren't reviewed like they should be, and probably not of the quality that you would expect them when they come in like that. But if you haven't done a good job of managing your client's expectations, and you haven't done a good job of creating a reasonable turnaround time, then you're in a deep hole right from the start. So we just all should be smart about looking at this service during the construction phase in a total picture.
Another expectation of the design professional is to provide clear definition of testing services, and you would typically do that in your technical specifications. That would be not only the testing services that the owner may be contracting for construction testing, but also any of the testing services that you are expecting the contractor to provide. Concrete testing for strength and slump and so on and so forth is typically done by the owner's testing agency, but then there are other tests that you may want to have done that the owner's testing agency is not going to provide. So you need to be clear on whether it's an owner testing agency issue or whether it's a contractor testing service that's going to be provided. So just be clear on that when you're doing your specs. And while it may not specifically state this in the contract, it certainly is going to state it in your licensing laws, is that an expectation of the design professional is to protect the public health, safety, and welfare. Jim, I don't know if you want to at this point share the story that we've talked about before, where an architect was found liable for a project that wasn't even his project. It was a project site that he was driving by. And I don't recall, Jim, if he was asked a question or he had seen.
It was an architect that was on vacation and saw a project that was under construction. Just out of curiosity, stopped and walked around the site to take a look at what was going on. It was a resort community, so he was just enjoying a beautiful day. He gave his card to someone who questioned his presence on the site, just to say, you know, hey, I'm Jim. This is not my project. I'm just here. I just wanted to take a look from, you know, an upper floor at the view, and do you mind if I just poke around? And certainly it was okay. And what happened later is that someone actually was critically injured on the site, and it so happened that it was that day. And because of things the way they are and some of the litigious natures of parts of our business, because he had identified himself and because he had communicated a way to get in touch with him, he was invited to the lawsuit. And he was invited very seriously because he had been on the job site and was, as Doug has pointed out here, responsible for health, safety, and welfare. And the court determined that he was there, that he was authorized and licensed to protect safety and public health, and because he had not done so, he actually ended up participating in the settlement. So it wasn't even his job, but because the expectation is so great that we are responsible, he got himself into a real mess there. There are a lot of lessons in that. I don't visit sites like I used to. I certainly don't go to ones that are not mine without, you know, my architect friend who is the person whose job that is. But it was just a very strange and bizarre story in turn of events.
Matthew, we'll take a pause and see if we have anything from the group.
Nope, everybody is still being pretty quiet, so I guess you're either cutting on all the points or they're shy today. I'm not sure which.
Okay, next we'll move on to the contractor. Contractor's rights and responsibilities. The contractor is responsible for accomplishing the work that's defined in the contract documents. The contractor is responsible to review the contract documents and notify the design professional of any errors or omissions that they become aware of. Now, that is not and should not be used by the design professional as a quality control measure. It shouldn't be viewed as such. It is there so that should the contractor be aware of an issue, he brings it to the attention of the design professional so they can address it. But it's not, again, a quality control function, just as when we are visiting the site and making site observations. We are not there to perform quality control for the contractor. The contractor is responsible for following the procedures for substitutions that are established in the contract documents, and I will add on not just substitutions but all the procedures, be they for submitting RFIs, payment applications, or whatever documentations, submittals that the contractor is responsible for. Those procedures need to be established and need to be followed. And again, as Jim said, we are the author of the book, so you need to make sure that you put in what you want to have happen and you take out what you don't want to have happen. If you only want 3 copies of submittals, change it to 3. From the standard language, there might be 5. So just, again, make sure that you are clear in the procedures that you establish, and make sure that you follow them and that you enforce that they be followed by all the parties. Contractor is responsible for furnishing competent supervision on the job site. It's responsible for maintaining a set of the documents on site that can be used by all parties as they visit the site. It's also typically, at least in the specs that I've put together, responsible for maintaining a copy of the submittals on site for use as well. Go out to a job site, see a condition, need to verify that it's in compliance with what was submitted. You need to be able to pull that submittal and look at it and not have to run back to your office and run back to the job site and bring your own copy. So those documents need to be accessible on site so that everyone can have access to them and use them. Contractor is responsible for the schedule and coordinating the deliveries of his subcontractors and the subs work. The site becomes the contractors once he starts that construction. It's kind of a temporary ownership of the site where the contractor is in control of how that site is managed and used. He's responsible for the safety on the site, how it gets used, where staging areas are. So unless you've got something defined in your documents that are specifically giving him those instructions, it's the contractors to determine. The contractor is responsible for indemnifying and holding harmless the owner, the owner's agents, and oftentimes the architects and design professionals from the contractor's performance. The contractor is typically responsible for providing performance and payment bonds. There may be some projects where you don't require that, but I would recommend it, and it typically is the case. The contractor is also responsible for furnishing the proper insurance. There's this workman's comp that he'll have to cover his workers. There's builder's risk. There's general liability. There's different insurances that are out there, and you need to review with the owner, at least with the builder's risk, whether or not the owner is going to provide that or whether they want it to flow through the contractor. So when you're putting your documents together, make sure that you've got all the insurances covered and the right person responsible for providing them. And as we mentioned before, the contractor is responsible for the safety on the job site.
You know, and Doug, back to that insurance for a second, this is another one of those things that can get put onto your schedule radar because these insurances will typically have expiration dates, and while you may not be specifically contracted to manage that process, it certainly is a good idea to be sure that the renewals are happening when they should. Often I have seen firms tie this to a submittal schedule and to a project construction schedule, ask the contractor to put milestones in there as reminders of when these renewals happen so that the owner as well as your firm is protected in the way that you expect to be. And you're sure that this insurance hasn't been canceled or terminated or expired.
That's a good point, especially when you've got a project that is going to last several months, over a year. Continuing on with the contractor's rights and responsibilities, to schedule and facilitate testing that you have specified, and again, that be it the owner, testing agency performing those services, or tests that the contractor needs to provide, they are responsible for scheduling that and coordinating with the owner's testing agency. They are They, being the contractor, are responsible for monitoring quality control and assurance. Again, the design professional site visits are not intended to be the contractor's quality control program. They're responsible for paying subcontractors and suppliers promptly. North Carolina has a Prompt Pay Act, and many states do, where the statute specifically spells out that the contractor needs to make these payments within a certain time period. And in North Carolina, it's not a pay when paid situation, or you have to pay whether you've been paid or not. So you've got that time period, and if you aren't making those payments within that time period, you're actually in violation of the state law, which goes beyond what you may have agreed to in your contract. Contractor is responsible for furnishing submittals to the design professional after the contractor has reviewed them. Oftentimes we'll get submittals and the contractor doesn't review them, he just slips them through. I can recall a project where I got a stair submittal, and it wasn't a stair that was for my project, it was a different project. I was not happy, and obviously returned it to the contractor and just re-emphasized that he has to review those things, in a typical language, review and approve the submittals prior to submitting them to the design professional. The contractor is responsible for scheduling and obtaining inspections by the authorities having jurisdiction. If the building inspectors out there, the mechanical inspectors, have those things scheduled on time so that he can keep his workflow going. And the contractor is also responsible for furnishing, typically at the end of the job, the record drawings, O&M manuals, and other project closeout data, so that the owner will have an accurate record of his project so that he can maintain it and operate it. Record drawings, I would suggest that throughout the course of the project you check on those to make sure that they're being maintained and updated on a regular basis. You don't want to get to the end of the job and have to worry about trying to get the contractor to go back and remember what happened 8 months ago when they were digging a footing and had to modify the condition because they ran into something, and the subcontractor's long gone and there's no accurate record of what was done. And so the owner gets a set of record drawings that are basically ineffective because they don't show the actual conditions. So take a look at those things on an ongoing basis so that you're providing the service that you're contracted to provide for your owner and getting him a decent set of record documents at the end of the project. It also will serve you and our profession well if, when the owner is doing an addition to that project, that the next architect, be it you or a fellow architect, has an accurate set of record drawings that they can work from. So make sure that you pay attention to those things. Jim, anything from you, or Matthew, anything from the audience before we move on to contractor expectations?
Not me, Doug. I think you got it.
Yeah, and still the audience is quiet, so feel free.
Expectations of the contractor. The contractor is expected to be knowledgeable, competent, and in compliance with the contract documents. You don't want a contractor trying to take on more than they're capable of, just like you would want a design professional that's never done a nuclear facility to design a new nuclear plant, and he doesn't know what he's doing. So you need to be knowledgeable, and you need to make sure that the expectation is that the contractor is in compliance with the contract documents, experience in the type of construction that is being performed. to provide quality and qualified workmen and superintendent on the site. And just as with the owner, the expectation is that the contractor be financially sound and be able to financially provide the services that they've contracted for. Big expectation is that they're going to complete the project in accordance with the contract documents, so that they will adhere to the schedule and that they will perform the work in a workmanlike manner. So just as the owner and design professional are expected to be fair and reasonable, the contractor is expected to be fair and reasonable as well, not only in pricing modifications, but in all their business dealings. The owner has the right to take partial occupancy of the facility, and the contractor is expected to accommodate that, should that not be the case. So other players in the process, consultants, other design professionals, subcontractors, suppliers, authorities having jurisdiction, testing agencies, commissioning agencies, you can see the list there. There are responsibilities and roles and expectations of them as well. We don't have time today to cover all of that. Suffice it, hopefully, to say that the players that flow under each particular party, the expectations kind of flow too. So just as with the design professional is expected to be fair and reasonable. The design professional's consultants are expected to be fair and reasonable. The design professional is expected to be competent. The design professional's consultants are expected to be competent. So same thing will flow through with the subcontractors and the suppliers under the contractor, so it kind of flows through. You get to some of these agencies or players that are outside of the three parties that are owner, contractor, and design professional, and they have their own set of expectations and responsibilities. And one in particular is authorities having jurisdiction. There may be some particular issues or idiosyncrasies that they have, especially if you're practicing in a jurisdiction that you're not familiar with. You need to get down there and talk to those guys and be familiar with their processes and what their expectations are. I've been in some jurisdictions where the individual that reviews the plans for issuing the building permit is the same individual that follows that project through and does the inspections on site. And I've been in some jurisdictions where it's two different people, and where our expectation as design professionals may be that once we get an interpretation during the design phase and it's gone through permitting, that's going to be the interpretation, where in fact, if the inspector in the field has a different interpretation, he's different from the guy that reviewed it, then you've got to deal with him and his interpretation. So you need to be aware of those little idiosyncrasies and make sure that you're dealing with those. Testing agencies, commission agents, and all, again, we're the authors of the documents, so you need to be clear when you're putting together your specifications what you are expecting from the testing agencies, the commissioning agents, special inspectors on your project. A lot of that is going to be, especially when you get to talking about some of the commissioning agencies, is going to involve communications back with the owner and what their expectations are. There may be expectations that lenders are having. Oftentimes, at the end of the project, you may get a letter from your owner that has a certification in it where the lender is expecting the architect to sign off on it, and the language in there may be something that you may not want to sign off on. So it's just, again, a matter of managing and communicating with the owner what the expectations are so that everybody is on the same page. Some of those lender certifications that I've seen are asking at the end of the job for the architect to certify that the buildings can be used for its intended purpose, that it's been built in accordance with plans and specs, that everything's perfect. And if you're not providing city services where you're out there on site 24 hours a day and you've got a man following each man that the contractor is working, how can you certify that everything is done exactly the way it was supposed to have been done? So you need to be careful about that and review those documents. And in the AA language, it talks about if the architect's going to sign a certification that he has a certain amount of time to review it prior to certifying it. Make sure you are enforcing that stuff and getting it to where everybody is comfortable with what it says, and so that it can do what it needs to do and provide the protections that it needs to have while not exposing you to an unreasonable risk.
Doug, I would add, one of the things that is an opportunity is that expectation management. I've been involved with projects where the majority of this list was invited to the pre-construction conference, and some invited to the continuing monthly conferences, particularly at times when they were involved with the construction. And it goes a long ways to building goodwill, establishing communication pathways, and often the result is that there is a real team atmosphere on the project. People aren't surprised, particularly the authorities having jurisdiction. They've known what's going on. Most of us, we work for someone, we report to someone, and as long as they're able to let folks know what the status of the work is, then they're pretty pleased. And so I would encourage you to expand your list of invitees to some of your project meetings.
And Jim mentioned the pre-construction conference several times throughout this presentation. That is an excellent opportunity to get all the parties together and review everybody's responsibilities and everybody's expectations so that we're all on the same page. I think that is a wonderful idea, especially if you can include these additional players. Matthew, anything from the group?
There's just one question here from Paul requesting a copy of today's presentation. So Paul, what'll happen is after this is done, I'll probably actually put both presentations from part 1 and part 2 together and make them available to be downloaded along with the recording viewing, both the YouTube channel and then on the web page. So again, look for that content in the next couple of days or so.
So again, in managing expectations, communication is the key. Communication is probably the most important aspect of the construction administration phase. I've seen some studies from some of the insurance agencies recently that say that some of the major or the most disputes are caused because of poor or lack of communication. So managing those expectations, keeping the communication lines open, being clear, concise, complete, very important. In your documentations, stick to the facts. Leave the colorful language out of it, even in speaking with someone. Keep it professional. Follow the proper lines of communication. If it's between the owner and the contractor, it should go through the design professional. To the contractor, subcontractors and suppliers, they need to go through the contractor. If they're to the design professionals, consultants, it needs to go through the design professional. I recall back in the days when, and it's still on the books to where you can do a multi-prime contract here in North Carolina, where we were working on a project and some of the parties, some of the subcontractors or major contractors were similar to another project. And in that situation, we had multi-prime, we had the GC, the general contractor, established as the project expediter, so he was to coordinate all of the work of all of the other contractors. And one of the subcontractors, because they were familiar with the consultants, the electrical consultant of the design professional, and had worked with them on several projects, there was some direct communication between the electrical consultant and this electrical contractor. It wasn't going through the architect, and it wasn't going through the contractor. And agreements were made between those two parties, and didn't flow through the communication like it was supposed to, and it ended up causing some major issues. And I don't want to take the time to get into the details, but that can be a big problem and cause a big problem for everybody. So make sure your consultants are aware that they are not to talk directly to subs and suppliers. It needs to go through you. And if you see or get wind of any of that happening, you need to nip it in the bud as soon as possible. So as we said, next month on the 27th, the fourth Tuesday of the month, we will talk about field reports. We want to talk about what goes into a field report and how we put them together. So again, I would ask that if you would please send copies of field reports to us so we can review those and talk about those at next month's meeting. And if you have used or are familiar with any software packages to help put together your field reports, if you're using one or have ever used one or are familiar with something, shoot us an email about that as well. Our emails are on the screen. And you can also email Matthew. He gave you his email address earlier. And with that, we want to thank you for participating. I think this is, Jim, one of the few times that we've gone through this without having a whole lot of participation from the group. And we look forward to getting a lot of participation next month when we're talking about these field reports.